Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. Got a little rain going on, so sorry for the white noise in the background. It is what it is. Wanted to give you a quick update about over the last month and a half or so on the 3M $6 billion settlement. And I'm just pulling this off of a lawyer's website and giving just the updates that they've given at some key kind of pivotal points. So for those that don't know, the 3M dual-ended earplugs weren't satisfactory, resulting in hearing loss and tinnitus, all that good stuff. There was a mass tort multi-district litigation which ensued. A bunch of veterans signed up and current military members and sued 3M. Came back with a $6 billion settlement to move forward, and now we're in the process now of doling out that $6 billion. Now there's some key kind of pivotal points. I'm going to start from January 15th and then just kind of bring us up to date here on what's going on for those of you that are curious about where this is in the process. So please hit the thumbs up, subscribe, share with a friend, all that good stuff. I really appreciate it. Let's jump into it. So January 15th, 2024, and again, I'm pulling this off of a lawyer's site. So our law firm is getting more calls from 3M earplugs now than we were before the settlement. Contrary to the narrative, the claims seem strong. Our firm is not taking new 3M earplug cases, and we are unaware of any firms that are. Now, if you're not involved in this and you think you should be in some way, somehow, contact a lawyer who, Google search 3M, lawsuit, lawyer, whatever, and contact one of them and see if you have any sort of options. All right, so moving on. In other words, the last multi-district litigation, MDL, case count is, so here's the question, how many cases are there for this $6 billion? 276,568 cases is the last multi-district litigation case count. So 276,568. Next one here is January 26th, 2024, and let's see what it says here. A law firm filed a motion to extend the registration deadline yesterday. The reason for this request is the slow mail at the Mississippi prison where the man is incarcerated from an armed robbery conviction. He was the driver of the getaway vehicle. I love how they're letting us know the situation here. The motion is accompanied by an affidavit from the man's lawyer addressing the prison's slow mail. That, well, it's going to help out everybody, right? And by extending it. So the affidavit is hazy on why they got so close to the deadline in the first place. It will be interesting to see how Judge Rogers rules. Indeed, being incarcerated makes the process of submitting a claim more challenging. Why not just show a little grace and give this man an opportunity to submit his claim? This is how I would lean if I were the judge, and Judge Rogers has a history of doing just that in this litigation. But the court has to balance that inclination with opening the Pandora's box of the precedent of the deadline not being the deadline in what is a very complicated settlement administratively. So if you do it for one, now all of a sudden there's going to be 15 other people that say, oh, well, this is the case here, or I'm slow here, or, my whatever, right? So you got to be careful with, is a deadline really a deadline? All right, moving on. January 30th, 2024, there was so much drama, and this one's interesting. There was so much drama around the stock sale. So for those that don't know, it was going to be $5 billion cash and $1 billion of stock liquidated, right? Or $1 billion worth of stock from 3M. So there, and then we were supposed to sell that and then get that basically transferred in as cash. So there was so much drama around the stock sale part of the settlement. Now 3M has decided to pay $1 billion in cash instead of using stock as part of its $6 billion settlement over claims of defective combat earplugs. This amendment to the settlement was made a month after they received court permission to issue unregistered stock. The change is finalized and outlined in a court order specifying a schedule for 6 payments. These payments will start after it's confirmed that at least 98%, that is the threshold for this settlement. 98% of claimants must agree to the settlement in order for it to move forward. So these payments will start after it's confirmed that at least 98% of claimants have agreed to participate in the settlement. A threshold 3M expects to exceed by March 25th, 2024. That's this month. Why is 3M choosing cash payments over stock? No idea. My guess is that it was a huge administrative hassle. So, interesting. Let's move on to the next update here, which was, let's see, February 20th. And this is the final one here. And then there's a little blurb above it. So we'll do this real quick. So February 20th, 2024. So this is, 10 days ago. Judge Rogers ordered that the deadline set forth in the now infamous CMO number 57 for the listed plaintiffs will be extended by 30 days from today. The extension is granted to allow for the corrections of any incorrect opt-out decisions previously made. Furthermore, if you are a plaintiff on the list who had a status conference scheduled with the multi-district litigation, that conference will be canceled. The court may reschedule these conferences at a future date if the necessary changes to the opt-out elections are not completed. The plaintiffs who are listed on an exhibit are given 10 days from the notification by the settlement administrator to either their primary lawyers or to themselves if they are representing pro se to complete and return the registration packet. Plaintiffs on the list who choose to participate in the expedited payment program must also submit any additional required documents to the firm Brown Greer PLC within the same 10-day window. No supplemental documents will be accepted after this deadline. If you read both of the court orders 4013 and 4014 for all of the administrative issues, but here are the deadlines for the opt-outs as I read it. 30-day deadlines by February 26, 2024. Claimants must meet production requirements detailed in sections blah, blah, blah. It'll be in the comments or in the description. Claimants must comply with the provisions notice requirements in section blah, blah, blah. Moving on, 60-day deadlines by 3/25/2024. Claimants are to submit expert reports as outlined in sections blah, blah. And then the latest possible date for status conference as specified in section blah, blah. All right. Additionally, claimants must serve a statute of limitations affidavit on defense counsel within 30 days of this order, providing specific information related to their use of the earplugs and potential litigation. Other deadlines from CMO 57 not associated with the election date remain unaffected by this order. However, failure to comply with the order's requirements may result in dismissal of a case with prejudice. I am posting this because it applies to many who do not have lawyers, but this is not legal advice. I am putting this up for entertainment, ? Yeah, that is it. Seriously, it is late at night and I'm tired. This is the law firm people writing this. It's like a little blog. Read the orders yourself. I will try and post them tomorrow. I did above, and talk to your lawyer if this applies to you. There is a frustration in the comments, and And anyway, so they're just kind of talking about the whole posting thing here. So the last piece here, it says, again, they're reiterating that they are not handling new 3M earplug lawsuits. So they must have been getting basically phone calls on it or what have you regarding this. So there is also some information coming out in email from some of the bigger law firms regarding the litigation. And I want to see here if I have a copy of it, which I do. I don't know how easy it's going to be to read it. But again, for those of you that are watching this, you're probably interested in the 3M stuff, and you probably are a claimant. So here it goes on. This is an email from Alistock, Witkin, Kreis, Overholtz. And it says, as you know, the settlement allocation master is creating a fund to award 3M settlement participants who have extraordinary injuries with compensation in addition to their base awards. So, money above the base award. Specifically, the master has identified 6 factual circumstances in which he will consider awarding additional compensation. The EIF award categories are tinnitus, 2, non-testing frequency hearing loss, 3, economic losses, 4, acoustic trauma and consequential injury, 5, hidden hearing loss, 6, single audiogram hearing loss. We, and I'm assuming this is the law firm, we will send you separate correspondence addressing each of the EIF award categories. You will receive 6 separate letters. In each letter, we will describe one of the EIF award categories, including eligibility requirements. Provide you with our initial assessment of whether you meet those eligibility requirements based on our records currently in our possession. And if applicable, ask you to provide us with additional information designed to allow us to complete your assessment of your eligibility. It will take longer to complete the evaluations of the records in our possession for some of the EIF award categories than others. As a result, you may receive letters addressing each EIF award category at different times. We are working as quickly as possible to provide you with an initial assessment for all EIF award categories. All right, so that concludes it. Thanks so much for watching. I appreciate you. Have a great one, and remember, if we don't take care of each other, something went wrong.